Okay. Okay. Good morning, everyone. Thank you very much for joining us for our webinar series. We're really excited to start off the year strong with our IP series. Today, we will be going over trade secrets in the digital age, balancing protection and disclosure. I'm really excited today to admit and to introduce some of our speakers for you all. Today, we have Douglas Link and Samuel Lewis. Douglas Link is a member in Cozen O'Connor's intellectual property department. He focuses his practice on patent prosecution and post-AIA review proceedings. Leveraging an electrical engineering background, he helps clients secure IP protection for electrical and software-related patents impacting a range of technologies, from quantum computing to financial processing, automotive components, antenna systems, optical guidance systems, and the like. He regularly manages cases involving software patents facing the ALICE test related to subject matter eligibility and has substantial post-IAI invalidity review proceedings experience at the USTPO. Doug also counsels clients on corporate IP management, patent portfolio management, and federal litigation infringement claims and defense. Our next presenter, Samuel Lewis, is the co-chair of Cozen O'Connor's copyright practice. He focuses his practice on intellectual property litigation and transactional matters involving computer, technology, and internet-related issues. He has represented a wide variety of clients, including motion picture companies, photographers, internet and computer-related companies, healthcare providers, and various other corporations seeking to secure rights, protect their intellectual property, and defend their rights on the internet. He has also served as outside general counsel to a variety of corporations. Sam's background as a photojournalist and computer software developer enables him to combine a practical understanding of content creation and a technical perspective to find solutions for his clients. So I hope you all join me in welcoming our presenters for today. And Doug, Sam, the floor is yours.
Thank you very much, Jalen.
Thank you.
Welcome to everyone. Before we get started, just wanted to throw out one request. If you have a question, if there's something you want to know, something we haven't addressed, please, by all means, either throw it into the chat, raise your hand, pipe up, feel free. This can be as interactive as all of you would like it to be. And frankly, we find that the more interactive these types of discussions are, the more useful they can be for everybody. So that's our little pitch. Go ahead and feel free to say something. Go ahead and feel free to raise your hand.
Yeah, so today we're just gonna super brief intro to Cozen and us, and then we're gonna go over the types of IP and kind of the toolbox that you guys have available, in particular where trade secrets fit into that. And then we'll go into some trade secret specific issues related to kind of the digital age and artificial intelligence. Yeah, so this is Cozen. We have 825 plus attorneys, 32 offices nationwide. We handle just about everything. Sam and I focus on the IP side, with my focus being more on the patents and Sam's focus being more on the copyright and trade secret and litigation as well. Okay. Just here's the offices. We can scan through that pretty quickly. And then
now the all-important disclaimers. I still think you picked this slide because it sort of looks like me. But in a nutshell, none of the views that we may express are necessarily those of Cozen, although frankly they probably are. So feel free to read this disclaimer if you wish. Otherwise, we'll press on.
Perfect. All right, so go ahead, Sam.
So let's talk about the types of IP and what's in our toolbox. Doug, go ahead.
Okay. So yeah, there's four real categories that we always look at. We have trademarks, copyrights, trade secrets, and patents. This presentation kind of focuses on the interface between patents and trade secrets and a little bit of copyrights as well. But when you look at trademarks, those are just symbols, words, sounds, designs, and what the purpose of those are is to identify the source of goods. The trademarks last forever, as long as you have continued use and you can show that continued use. Turning to copyrights real quickly, those are protecting expressions of an idea, but not the underlying ideas themselves. So functional aspects of the underlying idea itself. But you're protecting a work of authorship. And the term on copyrights is 70 years, or 95 or 120 if it's a work for hire. The important thing when you're looking at kind of the digital age with copyrights is open source and source code that you're looking to protect, and the relationship between that and artificial intelligence. The idea of open source is often referred to as copyleft, meaning they're using the copyright laws to protect the source code and then defining, if you use that source code, what you have to do to distribute or license that source code. The meat and bones of kind of what we're going over here today is trade secrets. The trade secret definition is information that it must derive independent economic value from being a secret, and it also has to be subject to reasonable efforts to maintain secrecy. Trade secrets are forever as long as the trade secret is kept secret. If it gets out, then you can't really put it back in the box. So it can get out either by employees accidentally releasing trade secrets to the public. It can get out by other companies creating and understanding the trade secret. If you think of Coca-Cola, for example, and Pepsi, they each have their own recipe, but those are two similar ideas and concepts of recipes. And so the trade secrets, you can't protect them other than you're maintaining their secrecy within your company. Patents, on the other hand, they protect new, useful, obvious, and non-obvious processes, machines, article and manufacture, and compositions. There's two different types of patents. You have design patents, which are 15 years from grant, and those are covering kind of the look and feel of a given product. Kind of keeping with our Coca-Cola theme, a very famous design patent was the shape of the glass Coca-Cola bottle. And utility patents are 20 years from filing.
Now, one thing just to keep in mind, and this starts to give you, I think, a better idea how these areas mix and match, or how they can work together. When it comes to something like computer software, the source code itself is considered a work of authorship. It is considered protectable expression, but copyright won't protect the ideas, the actual function flow, or the algorithms within the software. Trade secrets will protect the algorithms and the actual logic flows as long as they're not disclosed. And interestingly enough, the Copyright Act actually, or the Copyright Office, has regulations that allow the registration of copyrighted works or of software where the trade secrets have been redacted out of it, so that the trade secrets remain trade secrets. But again, this becomes sort of a mix and match. Another good example of sort of the mix and match is Gatorade. Gatorade, when it was first created, was patented. And as a result of the patenting process, once the patent issues, it's public. And when the patent expires, anybody in the world can look at that, whatever goes into that invention, and make it. Now, somewhere along the way, the University of Florida decided that the patent was not going to be sufficient, and they started, the University of Florida started looking at the idea that they might call it something else. The mark Gatorade came about. That is now a significantly strong brand, a significantly valuable brand.
Oh, okay. Is this about the polio storage?
Sorry,
Pardon me?
I think we have somebody not on mute.
Okay.
She muted.
Okay, perfect.
But the idea being, now you have protection. You can make Gatorade based on the formula that was described in the patent, but you cannot call it Gatorade. So again, mixing and matching these different tools gives you the ability to extend protection. And what you really want to be keeping in mind is you're looking for the best tools to fit whatever it is you're really trying to protect. So again, just generally, I'm sorry, Doug, go ahead.
Yeah, I was just to say this slide kind of summarizes what Sam was going over. And if we look at AI, for example, you're really sitting in the copyright, trade secret, and patent side. We're going to go over here the differences between whether it's difficult to get a patent versus trade secret, and maybe why you would go keep something trade secret versus patenting. And so we click on the next slide. Yeah. Just one last consideration on each of these. I think one of the most important things that can come from this slide is the understanding that if you have a patent, you're not getting the right to actually use that patented subject matter. A patent is an exclusive right. And so what that means is you get the right to exclude others from obtaining that or making, using, selling, offering to sell that patented invention. And so with that, you can get a patent on something. It's novel, unique, but maybe there's somebody else out there who has a fundamental aspect of what you need to actually practice that patent. So for example, if you get a patent on a car, but somebody out there has a patent on a specific tire, you maybe can stop others from using aspects of the car, but you maybe can't practice yours because you need that specific patent or that specific tire. Another key consideration is if you're going to disclose things out in the public, at least in the US, you have 12 months from that first public disclosure to file a patent. However, if you're considering an international IP strategy, then you likely want to have at least a provisional patent on file prior to any public disclosure.
One additional point to sort of throw into all of this, there is a reference here to work for hire, and that's something that is frequently misunderstood, or a concept that is frequently misunderstood. Work made for hire is a concept that exists solely within the copyright context, and it potentially gives the rights to what an employee, a full-time employee, creates within the scope and course of their employment. Gives the rights to those things to the employer as if the employer created them. Outside of that, it's got to be a matter of contract, and even beyond that, it doesn't encompass any of the other rights. So if you've got somebody creating things for your business, if you have them creating things that may very well include trade secrets and may include patents, failing to include a full assignment of rights, not just treating it as a work for hire, will cause you to lose the trade secrets. You won't gain ownership of any trade secrets that the person creates, and it will cause you to effectively lose or to not gain the patent rights. Businesses, employers are often looked at or often seen as having what are called shop rights, which is really a non-exclusive license to practice or to deal with the invention, but it is not the same thing as ownership, and it does not give you the same rights that you'd have in going out and enforcing those patent rights as the inventor would have. So trade secrets these days are actually governed by two different laws. One is the Uniform Trade Secrets Act that has been adopted. It's a uniform act that has been adopted by all of the states except for New York. Even the District of Columbia and Puerto Rico have adopted the Uniform Trade Secrets Act. Last major amendment was 1985. The nice thing about UTSA, as we call it, the Uniform Trade Secrets Act, is that it allows you to look at courts or decisions from other jurisdictions, because you have 49 state courts interpreting these acts and helping to refine the law. Interestingly enough, it does have a displacement or what is effectively preemption for other state causes of action that purport to provide the same remedies. Now, there is no registration requirement, and as much as there have been people talking about the ideas of bringing in some sort of registration system, especially now with the proliferation of blockchain, that is still something that is very much up in the air. And quite frankly, the only way to keep the secret is to maintain it as a secret. Federal law expanded the Economic Espionage Act of 1996 to include the Defend Trade Secrets Act in 2016. So you now have a federal law dealing with trade secrets. You have federal subject matter for purposes of going into court and enforcing it, as long as there is some sort of interstate commerce. As an interesting twist, the Defend Trade Secrets Act expressly recognizes the possibility of reverse engineering and excludes reverse engineering from what would be considered improper means in terms of acquiring the trade secret through improper means. The Uniform Trade Secrets Act does not have the same recognition when it comes to reverse engineering. The other sort of interesting thing about Defend Trade Secrets is it does not preempt or displace other claims for misappropriation. So as long as you have a UTSA claim, that can coexist and the federal law will not preempt it. Personally, I only know of one other law that effectively has the same sort of nod to state law, and that's dealing with electronic signatures. So, Doug, you want to take reasonable efforts, or you want me to?
Go ahead. Yeah.
So, what are reasonable efforts? You have to maintain reasonable efforts in order to maintain security of the secret. And increasingly, the courts are putting a fine point on this. One of the things right off the bat, if you're failing to use agreements with your employees, if you're failing to have them agree to maintain confidentiality, agree or recognize that they're handling or may be handling trade secret information, and agree to restrictions on their future use of it. If you're not taking those steps, there are a number of courts around the country that are already taking the position you failed to maintain reasonable efforts. In addition to that, frankly, you want to make sure that you are dealing with actual controls, physical controls as well. Now, that's not to say that all aspects of a trade secret have to be kept secret. And we've used Coke a couple of times, so I'll use it one more time as an example. Thanks to FDA labeling requirements, the ingredients must be listed on the product in order of descending predominance. So whatever exists within the product in the largest quantity is listed first, and then the next highest quantity is second, and so on. Well, there's not a lot of ingredients. So you can see if you can see the ingredient listing on the can of Coke here, you're talking about really a handful: carbonated water, high fructose corn syrup, caramel color, phosphoric acid, natural flavors, and caffeine. So right away, just the order of those ingredients gives you an idea as to what is in the product. That said, Coca-Cola and the formula for it, particularly the process to make it, the temperatures and the pressures under which these ingredients are combined and blended, are really what make up Coca-Cola's trade secret, and it's one of the longest running trade secrets in the country.
And so this slide is just kind of it's a checklist that is reasonable efforts is a sliding scale. So it depends on what the specific trade secret is. Is it a physical embodiment that you have stored away in a closet of your building, or is it a particular machine that you use to implement a manufacturing method? Or on the other hand, with software code, for example, is it a specific module of your software code that is stored within either on the cloud or within a secure server on site? That can all have input on what constitutes a reasonable effort. So This slide is just to kind of trigger some basics that often come up in arguments for reasonable efforts. And first and foremost, these first two kind of identify you taking reasonable steps to educate and inform your employees that you have trade secrets and your company as a culture values trade secrets, and that you've identified certain things as trade secrets. So one, you can have it in your handbook, but even more important and continuing to come up more and more in the litigation side is having a specific separate agreement that has a confidentiality, potentially assignment and other provisions, identifying that your company has trade secrets and here's the policy that we have associated with those trade secrets. On the next two bullet points, security and monitoring information control, are more, physical security. And then, so security and monitoring, you have physical security on, maybe you have, if it's, again, that machine that's locked in an area of your building, you have security protocols that only certain people who need to actually look at that machine and work on that machine and modify it have access to that. Your entire employee base does not have access to that area. If you think of KFC, for example, the joke of we have the recipe for the ingredients of our fried chicken locked away in a vault. That is a potential aspect of your physical security. Not only that is, and nowadays we have, electronic locking systems. So you're tracking access and how people are moving throughout your building, particularly if it's a physical embodiment. On the information and control side, most importantly, you're marking confidential information, but if you have something identified specifically as a trade secret, you're marking it further as trade secret. So you might have different levels of confidential information. You have highly confidential, internal use only, not to be disseminated outside of the company. Various levels of confidential information that you are consistently marking that information. And again, it's kind of tied to that employee handbook and/or agreement on this is how we view these various levels of confidentiality marking and what you should do if, one, you see something that you shouldn't, and two, you see something that's not marked, or various aspects of those markings. So we kind of went over trade secrets now. A very common question is, I have something, source code, let's say, an algorithm. Should I patent it? Or should I keep it, say, trade secret or potentially copyright? That is always a very gray answer. And so these are kind of 4 quick questions that always come up right away. First and foremost, are you going to disclose the concept? In the world of universities, for example, professors are often writing papers and their goal is to publish aspects. So there may be a situation where you have an AI algorithm that, as a professor, for example, you're wanting to publish this and disclose the meats and bones and how this algorithm actually operates. If that's the case, then it's almost a bright line. It is a bright line rule. You have to go the patent side. You could potentially go the copyright side as well. But really shift to the patent and copyright. The detectable question is, again, referring back to what I said, a patent is an exclusionary right. You have the right to stop others from using what you get patented. A key aspect of that is you have to be able to detect that somebody is actually using that patented invention. So in the realm of artificial intelligence, software code, for example, a lot of times the actual invention is being performed on the cloud and or it's in a black box and you don't really know whether that patent is actually being performed by somebody. You see the inputs maybe, and you see the outputs, and you can kind of derive that it has to be done this certain way, but you might not expressly know that. In that situation, maybe you want to lean towards trade secret and copyright side as opposed to patenting it, because in order to get a patent, there's a quid pro quo. You have to give all of the details that enable somebody to make and use the patented invention. And in return for that, you get a 20-year monopoly, essentially. So if you're not going to be able to enforce that monopoly and detect somebody using it, then maybe you don't want to give up your secret sauce and you want to keep it trade secret and or go the copyright route. Turning to the reverse engineering aspect, if you think it's something that's easily reverse engineerable, say you're selling something that's an output of an AI engine, right? And if you think that there's 3 ways that are potentially able to generate that output, and if somebody just sees the output, they're going to pick one or all 3 of those ways, then maybe you want to lean towards patenting it because it's easily to be reverse engineerable. If it's not so easily to be reverse engineerable, then you can lean more towards trade secret.
Doug, let me just throw in one additional concept there on the reverse engineering. There's case law that actually talks about the idea that if you have, let's say, trade secret software within a machine, a vending machine, for instance, but you're selling the machine and somebody's capable of buying that and then ultimately pulling the logic unit out of the machine and disassembling the software, or through other means reverse engineering that is still enough to be seen as the ability to destroy the secret and to prevent trade secret protection from applying. So, when you talk about something being capable of being reverse engineered, if you can conceive of how it would be reverse engineered, then it's probably not going to be seen as a secret. So you really want to be careful when you're engaging in that analysis, so that you don't think you're taking something down the trade secret route only to find out that there's not going to be protection for it once you start making it or selling it. Sorry, Doug, I'll let you take
No,
that.
You're good. So the last line is probably, if you ask any attorney, is my idea abstract? This is going to be the most difficult line to answer. And so patent law has shifted over the past 10 years, and software code and the software algorithms have been impacted greatly. They are more difficult to patent now, and the reason is the test for determining whether software is patentable asks, is it an abstract idea? And if it is an abstract idea, is there a practical application of that concept? And so really, I mean, there's many cases going on right now consistently since this law came out, and it's kind of all over the board, all over the map right now. So really what you look at is the software algorithm just implementing math? If that's the case, then it's likely going to be, it is going to be found to be abstract. Or is it implementing something that you can just do within your head? So assume that you're gathering data in a known way. You have a sensor out there that's gathering vibration data, for example. Assume that vibration data comes in, and then what you're trying to patent is actually how you're analyzing that vibration data and some output. If you're trying to patent it at that level of really what you're looking at in the vibration data, then there's a likely chance that it's going to be identified as an abstract idea. So what you need to do at that point then is say, okay, why am I doing this? So in a case of you're pulling that vibration data from a machine and you're looking at either predictive maintenance, or you're changing how that machine will operate based on what the calculation on that vibration data is doing, then you want to claim the higher level of controlling a machine in a certain way, because that is when you shift over into this practical application. So you're actually not claiming the algorithm itself, you're claiming what the output is doing to another device. And that's critical, where If you're really just inventing the algorithm itself, you might be in a harder area to patent. But if you have this practical application and you're kind of controlling something in a way that will improve that outside machine, then it leans toward being more easily patentable. And again, going back to that mindset of, if I'm not going to disclose this anyways, this algorithm on what I'm doing with that vibration data, I'm not going to be detecting anybody else from what they're doing with vibration data. It's potentially abstract, maybe you lean more towards trade secret. However, if you have, I'm going to disclose what I'm doing with that vibration data, I know I'm going to be able to detect it, or maybe not in this situation. And I'm also kind of leaning towards some other control of the machine, then you lean towards patents. So this is kind of a sliding scale on all four of these questions here that we often walk through with somebody who's got an idea for an invention and they're trying to figure out if they want to patent it or keep it trade secret.
One more point on the issue of abstract ideas. For a time in the late 90s and early 2000s, the Patent Office was granting an awful lot of patents for what really amounted to, or what today would be seen as, abstract ideas. In some cases, the inventors were even as obvious as saying, well, all we're doing is using the computer to automate now the function that people have carried out for years and years and years. And simply automating that function, generally speaking, is not going to be enough to overcome the abstract idea. It unfortunately took us a number of years of litigation and ultimately a change in legislation to finally get us to the point where now it almost feels like the pendulum has swung too far back the other way, and even legitimate ideas are being struck down as being abstract. So this is still something that is, for lack of a better term, a work in progress.
Sam, you want to take this?
Sure. So one of the risks, and as we're talking about, making or going through this decision route, this is not, unfortunately, a situation where you get to say, okay, I'm going to keep my ideas trade secret as long as I want, then I'm going to go out and get a patent. And in a fairly recent decision, this was just a couple of weeks, this was just decided a little more than a month ago, a company had developed a patented process that it was using to manufacture an artificial sweetener. However, it was selling the artificial sweetener prior to the time that it applied for the patent. In fact, it was selling the artificial sweetener more than a year before it applied for its patent. And that triggers what is called the on-sale bar. The Patent Act has a number, even the current Patent Act, which is the American Invents Act, has a number of bars that will prevent you from obtaining a patent. And this one's a little bit of a nasty one. Most people don't realize that if you're offering a product for sale and it's something that's going to be patentable, if it's offered for more than a year before you file your application, then you've lost your ability to get patent protection. And this extends it one step beyond in terms of, if you are now selling the product resulting from a patented process, that also triggers the bar. So here, what ended up happening was, and this was consistent with the law the way it was before the American Invents Act went into effect in 2011, correct me if I'm wrong there?
Yeah, 2013.
Okay. That the on-sale bar did apply even to the results of a patented process being sold. So this is a decision you need to make fairly early on. If you're going to be deciding to pursue patent protection or trade secret protection, you need to make that decision really soon and long before you start selling, even before you start advertising. Because again, once you go out and you advertise, once you go out and you sell, you are triggering statutory bars that may prevent you ultimately from getting a patent, even if the invention is patentable. So let's.
Can a robot write a symphony? Can a robot turn a canvas into a beautiful masterpiece? Can you?
So one of the hot topics these days, and you seemingly can't look anywhere without running into it, is artificial intelligence. Notwithstanding the fact that certainly we have been using AI in various systems and in various ways for quite a long time, before something like the large language models, the chat GPTs, if you will, became popular. But interestingly enough, we have no defined definition or no established definition of what artificial intelligence is. And even the various descriptions often are lacking to some degree. But the gist of all of this is you now have a situation, thanks to, in part, the GPTs, the large language models, and other neural nets, that particularly some of the ones dealing with images, where you have an AI that is capable of creating, or it is capable of interacting with us in a way that gives us the impression that it is real, it is alive, it is thinking. There are dangers to that too.
Ben, tell Agent Buchanan about yourself.
I am PIN, a physically independent neural network invented by Dr. Will Castor.
Can you prove that you are self-aware?
That's a difficult question, Dr. Tagger. Can you prove that you are?
Now, one of the things that I will admit that I have been a fan of AI really since the 70s, long before this concept was something that was realistic and on everybody's thoughts. But the idea of a machine that really could think for itself is something that has always intrigued me, and it was always something that I wanted to try to create. The problem, even what we have today, is we've got certain abilities that have advanced beyond a stage where, again, it gives the impression of a certain level of intelligence, but it really isn't. A large language model is really more of a statistical engine trying to figure out what words to be strung together, and it is not, under any circumstances, capable of abstract thinking. Now, what is abstract thinking in that sense? Abstract thinking is really about being able to string together discrete concepts or to understand relationships that aren't otherwise readily apparent from the information. Now, if you think of or have the ability to think of a dog and a cat as a pet as opposed to food, then you are probably starting to think in an abstract fashion. In some of the playing or some of the testing that we've done with some of the large language models, we decided to give it a series of tasks, one of which was to try to ask it to identify pieces within a patent. One of the things that's typically listed in a patent are prior art references. And those are listings of patent numbers, inventor names, and sometimes, although rarely, the title of the invention. But if you know patents, if you know anything about the patent system, you know that those three things, those three data points are all related. For a given patent, there's a patent number, there's an inventor name, and there's a title for that patent. We can look at the patent and we understand, based on abstract thinking, that those are related concepts. Interestingly enough, the large language models don't understand that. We asked it a series of questions about a patent. It gave me a set of numbers, not the numbers that actually appeared in the patent, but it gave me patent numbers, it gave me inventor names, and it gave me titles of inventions. And when we started looking more closely, we realized that what it had done was almost to take information from various patents and put them onto rollers like you would have in a Vegas slot machine, and then it spun the wheels. It didn't recognize that there was any connection between the wheel, and so if you ended up with inventor A and patent number B and description C, it thought that was a perfectly good combination to put together. So clearly we are still a long way from having a quote unquote AI that is capable of understanding the way we would like, and to be capable of truly abstract thinking. Now, that said, it hasn't changed people from trying to protect things. Now, this piece of art that you see, a recent entrance to paradise, is something that was created by Dr. Thaler's creativity machine. And Dr. Thaler originally applied for copyright protection for this work on behalf of the AI, claiming that the creativity machine, the AI itself, was the only author. The Copyright Office initially rejected it. There was some back and forth and some argument about it. But ultimately, the Copyright Office took the position that courts have uniformly declined to recognize copyright in works created absent any human involvement. And last April, the Copyright Office actually released an advisory to everybody who would be applying for copyrights, saying, if you have anything that is purely AI generated because it is not predictable, because the outcome is not predictable, there will be no protection for that. And to the extent that there is a human actor involved, or a human creator, a human author involved, the extent of the human author's contribution is something that is capable of being protected, but you have to disclaim the AI portion. Interestingly enough, this case just went to oral argument in front of the DC Circuit on September 19th. So talk about being timely. One of the things, again, that the court looked at was this fundamental idea that you have to be a human to create. This is actually Naruto, a crested macaque, who happened to grab a photographer's camera and push the button, and it became known as the monkey selfie. People on behalf of the animal tried to claim that somehow the animal owned the copyright to the work and that the photographer had absolutely no right to engage in any sort of licensing of that work. The Ninth Circuit ultimately upheld that, yes, you have to be a human in order to be an author, and that only humans have standing to sue for copyright infringement. Now, that has also filtered through into patent law, where Dr. Thaler strikes again. Doug, you want to take this?
Yeah. So the question here is, Dr. Thaler created an AI system that identified a new invention. And the question then was, can he file a patent with the USPTO and list the AI system device for the autonomous bootstrapping of unified science as the sole inventor? So the USPTO came back and said, no, an inventor has to be a human. It's relying again back on the copyright law and the analysis identified in that monkey selfie case, and said, no, in order to file a patent and get a patent, you have to be a human inventor. So we come into situations where, can you use large language models and other aspects of AI to create an inventive idea? And so what we have now is, there's kind of a sliding scale of, what are you prompting the artificial intelligence to provide, and how much of the creativity and the conception of the actual idea that you're trying to claim was conceived by the human, and then you use ChatGPT or some other large language model to reduce it to practice. So in patent law, there's a difference between conception of the idea and reduction to practice. If you have an engineer who you tell them, I want to build a chair with 4 legs, and they go and figure out, okay, I need one leg to be screwed on, I need one leg to be glued on, and those legs to be connected in a certain way. They didn't necessarily come up with the idea of a chair for 4 legs. Instead, they just told you how to reduce your idea into practice. And so right now, kind of this gray area of patent law, in general, the artificial intelligence cannot be an inventor. However, what we're going to see in the future is, okay, what is the level of understanding that the artificial intelligence actually created the idea and conceived of the idea versus just help somebody reduce an idea that they conceived to practice. So.
Now, one of the interesting aspects of the way some of this AI language is sort of making its way through the courts, the AI inventor or AI author language is making its way through the courts. The courts are actually starting to ask questions, in some cases based on very old law, of who can own property. Interestingly enough, at the oral argument in the Thaler copyright case, one of the cases that was discussed was Belford v. Scribner, a copyright case from 1892, where there was an argument that because a woman was the owner or was the author, and yet she lived in a state that didn't allow women who were married to own property, that somehow she wasn't the author and wasn't in a position to exercise rights in the copyrights. But you have even more fundamental questions like, okay, can an AI contract? One of Dr. Thaler's alternative arguments for obtaining copyright protection was to say, well, since he created the machine, he owns the machine created a work made for hire. And so one of the questions that he received was, okay, if it's a work made for hire, does the machine have the ability to contract? One of the concepts that would come into or works its way into a work made for hire is the idea that somebody would contract away those rights. And if you don't have a situation where your AI is capable of contracting or where your AI is capable of exercising and transacting property rights, then you may not necessarily have something where the AI is equivalent to an inventor or to an author. Now, interestingly enough, that has led some to point to what is perhaps this unique loophole in trade secret law. The Defend Trade Secrets Act does not define the term owner to mean a person. It actually allows the owner to be a person or entity. And right now, I mean, we might think on the one hand, an entity means some sort of legal organization, some sort of business organization, but it has not been interpreted in such a way that it has to be that. And so entity could be almost anything as an owner, notwithstanding some of the issues that we have when it comes to the AI being in a position to contract or the AI being in a position to transact any property rights. But there is this growing body of thought that an AI might be able to create something that is subject to trade secret protection. Now, the potential pitfall right now, and what nobody seems to know the answer to, is the AI or is the neural net exercising some sort of reasonable means for protecting the trade secret? And this is where it gets a little bit messy, because by and large, we don't have a full understanding as to what the AIs are retaining when it generates an output, and particularly when it is interacting with us. So you can ask an AI a question, and some of the information that is contained within the question may ultimately be integrated, if you will, into the neural net in such a way that that information may ultimately come back out. We've started to see this actually a little bit with some of the large language models where we've done testing. Again, simple reading documents and providing information about what's in the document. If the AI comes back with an incorrect answer, the subsequent questions trying to arrive at a correct one often see the same kind of information coming back out. So there doesn't seem to be, at least right now with many of the generative AIs, a good way of correcting it so it knows not to integrate this interaction into its neural net and then not to regurgitate the same wrong answer on the back end. But as I'll let Doug take, there's an even more sort of terrifying aspect when it comes to exposing trade secrets to an AI.
Yeah, and so one more slide. Yeah, I mean, last year there was a situation, and it was Samsung Electronics. There's tons of blogs on this. They banned the use of ChatGPT and other AI, large language models. The reason for that is they had one of their technicians, engineers using ChatGPT, and they input some trade secret and source code that the company wanted to keep trade secret. Right then, they were using the open version of ChatGPT, and so they input the source code, and the source code was then kept by OpenAI, or really it would be any large language model that you don't have security provisions associated with. So they ingested that, and now the source code became part of the large language model. So really, this kind of takes it back to what we were talking about in the beginning, and the reasonable efforts of keeping secrecy. We know that AI is going to be prevalent, and it's going to continue to be prevalent. So if you're a company thinking about bringing in those types of modules, you want to identify security protocols, where things are stored, what the AI is doing with the data. Can it reuse to train an internal version of the model, or can the data then be, and the outputs be used to train the overall publicly available model? These are all very common questions now that even in the past 6 months, people are starting to think about. However, when this was first released and people started using large language models, there was some pitfalls that occurred. So I think if we go back to kind of the concept of balancing disclosure versus can I trade secret, you want to first start with the basics of trade secreting, and that is maintaining the information or a concept as a secret is the most important aspect, because once it gets out, you can't bring it back in. So.
All right, and one other sort of unique thing when it comes to trade secrets, and this is for somebody who litigates as many of these cases as I do, it is in some respects the bane of my existence. But there is a growing body of law around the country, and in some courts, and in fact, in the Eastern District of Louisiana, they have now put this into the local rules. In California, it's actually been part of their statutory law for more than 20 years. If you bring a trade secret case, one of the things you have to do as a plaintiff is to be prepared to identify with reasonable particularity what your secrets are. You need to know what they are, what's at issue, and be prepared to put them into a document so that the court understands them and the defendant understands them. Now, for companies that really do maintain and have real trade secrets, this is generally not a big deal. And hopefully they have a lot of other information about who had access and log files and so on. So you can trace who was really accessing the information and why you have a basis for believing that somebody has taken or misappropriated the secret. But it is, and I run into this time and time again, where plaintiffs' lawyers don't realize they need to do this homework up front. You need to have, again, an idea as to what your trade secrets are. And if you can't really list them out, it's going to be difficult to litigate them. And this is not the kind of litigation where you can simply say, as the plaintiff, I'm going to mold my case around what I see in discovery. The reality is that you're never going to get discovery. The case law now very clearly provides that until you have identified your trade secrets at issue with reasonable particularity, you don't get any discovery from the defendant as to what they may have taken or what they may have in their possession. So something just to keep in mind.
Yep.
And then, Doug, go ahead, take it.
Yeah, that wraps it up. So this slide just says we can help you with a lot of things. If you have any questions, please don't hesitate to reach out. We're here to help you guys, and as you go along.
Any questions in the couple of minutes we have left? Colin, go ahead. Unmute yourself, please.
Hello, can you hear me?
Yes.
So this is a pretty basic question, but I was a little confused by something you said earlier about patents, and forgive me, I am new. You talked about the right to exclude others, but not the right to use. I wanted to clarify that with AI, I suppose, because can AIs actually like use patents, or is that exclusive to human beings?
Well, no, actually, that's something that is interestingly enough, it's becoming part of what I've termed the sort of paradox of generative AI. You have a situation increasingly where the AI is capable of creating something that you can't own, but at the same time, it's capable of creating something that can result in a claim of infringement. And it's ultimately the human who caused it to generate the infringing work that will face liability for the infringement. So you have a situation in the patent context where the AI, it could come up with the invention, but it can't own it. But by the same token, if what the AI is doing is carrying out the steps of a system or carrying out a process that is patented, there may very well be liability for that, and that liability doesn't begin and end with the AI. It's going to begin and end with the humans who are causing it to utilize that process.
Okay, thank you very much.
Any other questions? Well, Jalen, with that, I guess we'll turn it back over to you.
Awesome. Well, Doug and Sam, thank you both so much for that overview of trade secrets and patents. One of my takeaways is the questions about patent protection. Are you going to disclose? Is it detectable? Is it reverse engineerable? And then kind of the balance of is it too abstract, or is there a practical application? I always love a good iRobot reference, so I really appreciate that as well. And I think one of the bigger takeaways is know what your secrets are. So thank you again so much, Doug and Sam. Once again, this will be recorded. This will be sent out, but keep an eye out for some of our upcoming programs. All right, so we have another IP webinar coming up. It is going to be patents for disruptive technologies and strategies for the AI era. That's a fun common theme here. October 15th, we are going to have a faculty innovation mixer. This is going to be uptown in the Howard Tilton Library. And then on October 16th, we're going to have another webinar featuring customer discovery. So for all of you who joined us, once again, thank you all very much. And once again, we've got my favorite picture of myself saying, peace out, and we'll see you next time.
Thank you.